My name is Fernando Dubove. I'm an immigration attorney here in Dallas, and today I'd like to speak about President Trump's migrant protection protocols, the cynically named migrant protection protocols issued by President Trump in January that requires persons who are seeking asylum in the United States to wait outside the United States until their appointment with an immigration judge. Cynically named because there's no effort to protect the migrants. Rather, they are forced to wait on border towns in Mexico like Ciudad Juarez or Matamoros or Nuevo Laredo, where cartels are waiting to feast and to prey on the immigrants in that country. The Migrant Protection Program applies to persons who are seeking political asylum in the United States. Primarily, this involves Central Americans from El Salvador and Honduras who are fleeing because of the pandilleros, the gangs, or gang recruitment or gang violence. But more and more, I'm seeing persons that are escaping to the United States from Cuba and from Nicaragua because of the student movement uprising against President Ortega. Cubans are on the uprising seeking for asylum because there is no longer the wet sand, dry sand policy that allowed Cubans to enter the United States. Now I want to explain to you, as President Trump explains, how the Migrant Protection Program is supposed to work and what you can do to prepare for that if you or a family member are trapped at the border trying to enter the United States to seek asylum. The Department of Homeland Security press release states, certain persons attempting to enter the United States who claim asylum will no longer be released into the United States. Instead, those persons will be given a notice to appear for their immigration court hearing and will return to Mexico until that hearing date. The notice to appear is a very important document. That's what will give the immigrant applying for asylum the hearing with the immigration judge. That first hearing will occur with the immigration judge usually either in San Antonio or in Harlingen, not at the border. The person seeking asylum will be given the notice to appear and a hearing notice to appear at the bridge in the United States at 4:30 in the morning. At that point, they will provide the immigration officer the letter reflecting they have a hearing with the judge, then be allowed to enter to the United States side of the bridge, where they will wait in a separate room to the side until they have their hearing with the immigration judge. It's important to realize the immigration judge will not be at that hearing in person. If the person is waiting in Matamoros and crosses into Brownsville, or in Laredo and crosses into Laredo, or in Juarez and crosses into El Paso, the immigration judge will be, in the case of Brownsville, 30-40 miles away in Harlingen. If you hire an attorney for that hearing, you will want the attorney to be in Harlingen with the judge, not at the bridge with the client. That way, your attorney can present to the immigration judge a prepared asylum application. The sooner you give that asylum application to the immigration judge, the sooner your client will have the hearing with their immigration judge to consider whether they will be allowed to enter the United States or not. The immigration judge does not have the jurisdiction to allow the person to enter the United States. If the person applying for the asylum is in danger in Mexico because they have been robbed or they have been targeted by the cartels, at the conclusion of the hearing, they must ask the immigration judge for a hearing to be allowed to enter the United States, and they must tell the judge, my life is in danger while I wait in Mexico. At that point, the judge will instruct the immigration attorney, the attorney for the Department of Homeland Security, to give that person a credible, fair interview at the bridge, where the immigrant will have an interview with an officer to determine whether they have established a reasonable fear of staying in Mexico. Now let me read you what the Department of Homeland Security considers reasonable fear. A person should not be involuntarily returned to Mexico if the person would more likely than not be persecuted on account of race, religion, nationality, member in a particular social group, or political opinion. They would more likely than not be tortured. If so, they may be allowed to enter the United States, waiting for that hearing with the immigration judge. As a rule, this will require the immigrant to prove to the immigration judge that they have suffered some kind of persecution or they have been targeted by the cartels, usually because they are immigrants crossing the country and the cartels know that immigrants are traveling with money. But then you must present that information to the asylum officer, who will then decide whether they let you come into the United States or not. I recently had my first case involving this new program, what's known as the MPP, the Migrant Protection Protocol. And this is my personal experience from that hearing. First of all, I flew in to Brownsville the day before the hearing. crossed into Matamoros so I could speak with my client, who's from Cuba, and talk to her about the basis for her fear and review the application that we had already prepared. If you hire an attorney, you want to do it with enough time so the attorney can talk to the family in the United States and even to the client waiting in Mexico so they can review the basis for their asylum and go to that first hearing with the immigration judge with an application ready to file. Remember, the sooner you file that application, the sooner the client will have their final hearing with an immigration judge, and si Dios quiere, the sooner that person will be in the United States. I wound up spending the night in Matamoros in the same hotel as my client. The hotel was well secured. It's a dangerous place to be, and just being outside at night is fearful. At 4 o'clock in the morning, we hired a taxi that the hotel believed was safe, and they took us to the bridge. We crossed from the Mexican side of the bridge to the halfway point in the Rio Grande, where the U.S. Immigration Office was waiting at 4:15 and asked my client for her papers to show that she had a hearing with the immigration judge. I then left her there so she could go on to the interview, and I went back to my car on the Brownsville side and drove to Harlingen, about 45 minutes away, to be with the judge and the immigration attorney for that hearing. The hearing began at 8:30 in the morning. At the beginning of the hearing, I explained to the judge that my client was seeking asylum, withholding of removal, and protection of the Convention Against Torture. We submitted that day in court a copy of the asylum application, and the judge gave us a trial date for about a month and a half away. As a rule, the final hearing will be about a month and a half from the first hearing. But the sooner you submit the application, the sooner the person will have their trial date. The immigration judge does not have the jurisdiction to allow the person to enter the United States. At the conclusion of the hearing, I advised the immigration judge and the prosecutor that my client was fearful for her life while waiting in Mexico because, number one, she was a single woman in her 20s, and there was much cartel and gang activity there in Matamoros. Number two, my client and some of the people traveling with her had already been robbed twice while in Mexico, crossing into the United States. Because I mentioned that to the attorney and the immigration judge had ordered the trial attorney for the Department of Homeland Security to immediately do a credible fear interview with my client to determine whether she would be allowed to enter the United States. That interview was conducted within an hour. Just as a recommendation, if you have an attorney, you want to make sure that the person who is going to have that credible fear interview immediately after the conclusion of the hearing with the immigration judge, tell the asylum officer, I want to wait for my attorney to be present so he can be with me at my asylum interview. Unfortunately, I didn't know that my client was going to get an asylum interview within an hour of me finishing the hearing, so I drove immediately back from Harlingen to Brownsville, crossed to the tent cities that are literally set up on the bridge, on the U.S. side of the bridge, where the Department of Homeland Security is holding these people for their credible fear interviews. By the time I arrived, my client already had their credible fear interview, and her interview was denied. As a result, she is going to have to wait in Mexico until she has her final hearing. Now, there are 2 email addresses where we can submit additional documents for the Department of Homeland Security to consider to deciding whether they let her come into the United States. We're in the process of doing that. We haven't heard a response yet, but if that does come out, I will advise you all in a future video on the results of those. But as a rule, as I mentioned earlier, based on President Trump's protocol, the immigrant who is claiming fear of staying in Mexico must show that they are being targeted because they are part of a particular social group. The social group I'm advising my clients to mention is they are immigrants traveling across Mexico. They are being targeted specifically because they are immigrants and because the cartels know that immigrants travel with all their money to be able to get into the U.S. And that makes them the target of gang activity. And the police in Mexico is unable to control the cartels. And that is the basis to hopefully get the asylum applicant into the United States safely with family members. With every new tweet, President Trump tries to take away more and more of immigrants' rights to apply for asylum in this country, to seek safe harbor in the United States. We still have rights, but your rights don't mean anything if you don't use them. My name's Fernando Dubove. I'm an immigration attorney, and I've been doing this for over 25 years, and it is a brave new world out there right now. But we still have rights. In the Migrant Protection Protocol, and immigration judges who are sworn to uphold the law can still consider your asylum case. If you have a family member in this situation, I advise you get an attorney as quickly as possible and begin as quickly as possible preparing their asylum application for their hearing with an immigration judge. Thank you and good luck.